All right, welcome back. We've got a busy one today. So basically, without hiding the ball, we're going to first head up to Idaho, cover Scofield versus Guillard, then travel down to Las Vegas and look at a little bit of Castro versus LVMPD, although the big update for that is going to be a future stream just because that's going to be, well, it's not directly related and it's going to be a mess. And then we'll jet across the country back to Massachusetts for DeCastro versus Abrams. So I've I've been meaning to do this for a while. Basically, if I have multiple subjects, multiple lawsuits, do them all in one video instead of chopping them up. It just, I think, even though the length of video will come out about the same as opposed to chopping it up, and it's less work doing one big video and going through the whole upload process and whatnot. So it's just, I think it'll work better, but you guys might disagree. But either way, I've been meaning to do it for a while, so here we go. And like I said, with Vegas, the thing that I'm not covering, like I said, it's not directly related. It's going to be the Jensen intervener full motion, and it was not filed because the judge isn't allowing him to file it because he's not a party to the suit. But luckily, he put it on Twitter, so just for our amusement, I'll go over that in a future video. But with that, like I said, we'll start in Idaho today, and that's Scofield versus Guillard, the TikTok psychic case. I know most of you haven't been following that one, even though it's way more interesting than DeCastro, uh, any of Delete Lawz cases. So last time we were here, basically June 6th, we had a motion to dismiss from Professor Scofield, and then alleged summons issued to her attorneys because Guillard, the TikTok psychic, is trying to claim that they're co-defendants. And then the last thing we covered was the motion to quash from the attorneys because they're not properly parts of the case. They're not proper co-defendants. Well, Guillard isn't getting the message. So first things first, we have proof of service. This one as to the associate attorney, Corey Carone, allegedly on the 9th of June, on 6/9, nice, and served on the receptionist at Stoll Reeves, the law firm, and served by, is that Acacia or Alicia or something Fisher, the process server? One way or another, that's going to be a waste of money because the motion to quash is going to be successful. But and then there's a identical proof of service for, you can serve all you want, but if they're not properly defendants in the case, service is just a waste. But I expect the motion to quash will be granted after Guillard has an opportunity to respond to it, of course. But so moving on though, one of one of the reasons I wanted to cover this, in addition to the Delete Lawz cases today, is because, well, I think it's actually relevant to our discussions about Delete Lawz. Because, we've been saying for months that Delete Lawz, with all his claims that he's a 20-year constitutional law scholar, he's this legal savant. Well, all he knows how to do is file lawsuits. He doesn't know how to litigate lawsuits. His entire strategy is amendments until finally they're thrown out. He does not know how to proceed, but we also think he's scared of proceeding because he's terrified of what's going to come out in discovery. So he does everything he can to keep a lawsuit going, but without it going into discovery. As we've seen in his case that I haven't been covering, the Ironton suit, De Castro versus Wagner, the the defendants there sent him a proposed discovery plan, and he lost his mind. He absolutely lost his mind because they sent it before the discovery conference. Well, as you for those of you who have been following Scofield versus Guillard, you'll know, hey, we haven't proceeded, we haven't reached the discovery conference yet. That's going to be on July 6th, I believe. And let's see. So yeah, the scheduling conference on July 6th, and on or before Thursday, July 29th, the parties must file with the court the joint litigation plan and discovery plans. So you've got to get those, you've got to have the plans in before the conference. And because in Ironton they haven't had the conference, Delete Lawz lost his mind that how dare you even think about discovery yet? Well, because of that, I figured, you know what? It'll be good to see what a scheduling conference, a proposed litigation plan looks like, and a proposed discovery plan looks like. Because we may never get to those in any of the Delete Lawz lawsuits. And so, since I'm going to be covering it anyway for Scofield versus Guillard, I figure, you guys may as well all see it because it's relevant. So, with that, let's first take a look at the scheduling plan, the litigation plan, which it says revised effective 1/1/2019. That's because, they're working off of a template. It's fill in the blanks. So presiding judge Patricio, however, he's of course the magistrate judge in Idaho because their federal judiciary is tiny. Scheduling conference on July 6th. Case number, its nature of the suit is defamation. Case name Scofield versus Guillard. Party submitting plan. The plan has been stipulated to by all parties. So basically, the Professor Scofield's attorneys have put this together, but because they're not childish. I mean, Guillard, we can agree, is nuts, but she's not a dickhead like Delete Lawz. So Professor Scofield's attorneys are able to meet and confer and say, hey, here's our proposed scheduling plan. Do you have any input? Do you want to, do yours? We can work on it. It's stipulated, though. So since it's stipulated, even though it's proposed, it's going to be accepted. And you'll see there's a box to check if the plan hasn't been stipulated. So case management track. Indicate the track that best fits your case. Designation of a track is not binding, but will assist the court in assessing its workload and selecting a trial date and discovery schedule that meets counsel's needs. And they've clicked on the expedited track, and it says cases on this track will typically be set for trial approximately 9 to 12 months following the management conference, take 4 days or less to try, and involve limited discovery. So, assuming it goes to trial, we can expect it, 9 to 12 months from July. So that's what, April through the end of June, early July of next year. The standard track would be typically set for trial 12 to 15 months following the case management conference, take 5 to 10 days to try, and involve typical discovery. Most cases fall within this category. Well, that's kind of obvious since it's the standard track. And then there's the complex track, cases typically set for trial 15 to 24 months following case management conference, more than 10 days to try, involve extensive discovery, and involve extensive expert testimony. So even though Dept v. Heard was a Virginia state court case, not federal, if it was federal, it would have been obviously a complex track, very complex. And then there's the legal track, and cases that involve legal issues likely to be resolved by motion rather than trial. There will be little, if any, discovery. A motion hearing will be set at the case management conference. So that's if they expect, a summary judgment or something like that. So next, dispositive motions filing cutoff date, January 12th, 2024. So January 12th, that's the last day to file summary judgment or any other 12B motions, although most of those won't be available by then because you've got to file them before an answer. So this is a critical event for case management and will dictate when the trial will be set. Unless the case is resolved through dispositive motions, the case will likely be tried within 6 months following this date. Therefore, this cutoff date should be set within 3 to 6 months following the case management conference for an expedited track case, 6 to 9 months for a standard track case, and 12 to 18 months for a complex track case. A motion to amend to add a claim for punitive damages must be filed by the dispositive motion cutoff date. If the parties desire an earlier or later date to accommodate discovery related to the same, they should raise the issue with the court during the scheduling conference. And then next, joinder of parties and amendment of pleadings cutoff date, August 11th, 2023. Not more than 3 months following the case management conference. This is the deadline for filing of a motion to amend for reasons other than adding a claim for punitive damages. So that, I mean, most of this is pretty self-explanatory. No amended complaints after this date. No adding of additional parties. Next, we have alternative dispute resolution options pursuant to Local Rule 16.1 and 16.4. The parties must meet and confer about 1, whether they might benefit from participating in some form of ADR process. 2, which type of ADR process is best suited to the specific circumstances in their case. And 3, when the most appropriate time would be for the ADR session to be held. And check preference. There's options for mediation, settlement, arbitration. They clicked other. The parties do not believe ADR would be beneficial. thus ADR to be held by not applicable. But it continues, regardless of whether the parties choose mediation, a judicially supervised settlement conference, or some other form of ADR, the court strongly encourages the attorneys to schedule ADR early in the proceedings and in advance of filing of dispositive motions to reduce the cost of litigation for their clients. In addition, the trial will be set very soon after the resolution of dispositive motions, so that there will be little time to engage in meaningful ADR after that date. 5. Discovery Plan. Federal Rule of Civil Procedure 26F, June 29th, 2023. And we're going to, like I said, next look at the proposed discovery plan. So, as required by Rule 26F, the parties must submit a detailed discovery plan to the court in advance of the case management conference. The court expects the discovery plan will represent a good faith effort by all counsel to expedite the process and reduce the cost of discovery. At a minimum, the plan shall cover the topics set forth in Rule 26F3, including the timing of initial disclosures, the subjects on which discovery is necessary, the timing of discovery, when discovery will be completed, whether phasing of discovery is appropriate, issues concerning ESI, that's electronically stored information, which need to be resolved, and whether there is a dispute among the parties in applying the proportionality standard of Rule 26B1. Next, we have the factual discovery cutoff date, which is December 15th, 2023, which is 15 to 30 days prior to the dispositive motion cutoff. Counsel may, however, stipulate that after dispositive motions have been decided, the parties will engage in additional discovery focused on trial preparation. This may include discovery relating to damage claims and other issues not typically resolved by dispositive motions. Expert discovery cutoff date, January 5th, 2024. So that's the date, basically, assuming there are expert witnesses, the opposition gets to have depositions with your expert witnesses, and the cutoff date is January 5th. So, expert testimony disclosures, local rule 26.2b. And those include plaintiff identity and disclose expert witnesses by November 6th, 2023, 60 days prior to the discovery cutoff. Defendant identify and disclose expert witnesses by December 6th, 2023, 30 days after plaintiff's disclosure. Plaintiff's disclosure of rebuttal experts by December 20th, 2023, 2 weeks after defendant's disclosure, and all discovery relevant to experts completed by January 5th, 2024. And you'll remember, going back to the Johnny Depp trial, that that they had experts for their case, their own experts, and then listened to the opposing experts, and then they either brought back their experts for rebuttal, or in some cases they brought brand new experts just for rebuttal purposes. And then the trial date. The date of the trial and the pretrial conference will be scheduled at a trial scheduling conference following the resolution of dispositive motions or the conclusion of court-supervised ADR. So that's a bog standard what a scheduling, or at least a proposed scheduling plan looks like. And, you know, the court's going to approve it because you know, it's the standard plan basically. So you know, frequently you'll go into court, and if there's no objections and you know you both agree, you'll go into court for a scheduling conference, or before a scheduling conference even, and the judge will ask, counsel, what do you propose for scheduling? And you'll just say, Your Honor, we propose standard terms for scheduling. The judge will say, all right, discovery by this date, experts by this date, blah blah blah, go down the list, and then, is that all right with counsel? Sure. And you're done. So moving on, we have the plaintiff's proposed discovery plan, which is not agreed upon, apparently. So the parties have been unable to reach an agreement on the discovery plan, in part because defendant Ashley Guillard insists that plaintiff Rebecca Scofield must agree to waive the protections of the attorney-client privilege. Waive the protections of the work product doctrine and take responsibility for documents in the possession, custody, or control of non-party, the University of Idaho. That is what we call insane. Plaintiff Rebecca Scofield does not agree to those demands, so she submits the below proposed discovery plan for the court's consideration. Out of any of the discovery plans, this is the one that's going to be accepted, because I mean, there is absolutely no way on earth that the judge is going to allow her to breach attorney-client privilege or work product privilege. Work product privilege being the work that the attorneys have done on the case, and their case research, case files, notes that they've taken. That's just absolute insanity to even propose. I mean, it's such extreme circumstances that allow that. You're thinking Michael Cohen, Donald Trump's former attorney, where he's a co-conspirator in a crime. That's literally the level it takes to breach attorney-client privilege like this. So, preservation and proportionality. The parties have applied the proportionality standard in Rule 26b(1) to determine what information should be preserved and what information should not be preserved. Electronically stored information. With regard to ESI, the parties agree that date range: only ESI created or received between June 1st, 2021 and the present will be preserved. Because and this is what the proportionality is. You know, you can't expect her to retain records from 10 years ago, or you know, maintain her phone records from before a relevant portion. And you know, the Idaho murders took place in November 2022. So why are they having her save her ESI from June 1st, 2021 on? Well, because that's we've seen in previous filings, Professor Scofield's attorneys have said defendant Ashley Guillard has been engaged in this sort of nonsense in other high-profile criminal cases since she created her TikTok account in 2021. So, like, she's been involved, doing her fan fiction with respect to the Shanquilla Robinson case and various others. So I'm guessing they want that preserved so that they can say, hey, look, this isn't the first time she's done it. That this is a ongoing pattern. So that's why they want from June 1st, 2021 preserved. Scope of preservation. The parties agree to, and that this is proposed. So, but if the judge stamps it as approved, then the parties will have agreed to preserve the following types of electronically stored information. All social media or other online content, including, without limitation, TikTok videos, YouTube videos, and blog posts, instant messages, email communications, text messages, Word documents, from the following custodians or job titles: Rebecca Scofield and Ashley Guillard. So not from non-party, the University of Idaho, or from non-parties who have attorney-client and attorney-work product privilege. Anyway, the attorneys. From the following systems, servers, and databases: all devices, systems, servers, or databases used by and under the control of Rebecca Scofield or Ashley Guillard. Preserved, but not searched. These data sources are not reasonably accessible because of undue burden or cost pursuant to Rule 26B2B, and ESI from these sources will be preserved, but not searched, reviewed, or produced. None. Not preserved. Among the sources of data the parties agree are not reasonably accessible pursuant to Rule 26B2B and shall not be preserved are the following. None. ESI retention protocols. The parties agree that there are no document and ESI retention destruction protocols that need to be modified. Cost sharing. The parties agree to bear their own costs for preservation of e-discovery. Initial disclosures. The parties agree to modify the deadlines in Rule 26A to allow initial disclosures to be provided on the dates below. All other provisions of Rule 26A shall remain in effect. Plaintiff, June 30th, 2023. Defendant, June 30th, 2023. So, Rule 26A has certain things that are required as initial disclosures, as this says. It's basically stuff that you have to provide whether it's asked for or not. If you're involved in a lawsuit, these initial disclosures you have to provide, period. And they're suggesting they've got to be provided by June 30th. Now, when is June 30th in relation to the July 6th conference? It's a week before. So when Ironton, and I say Ironton, but that includes the Lawrence County defendants, but when Ironton sent Delete Lawz, hey, this is discovery we're going to want. It's like he might have to submit his initial disclosures before the discovery plan anyway. So scope of discovery. Scope. Discovery is necessary on the following subjects or issues. For plaintiff, 1. Defendant's false statements about plaintiff's relationship with Kaylee Gonsalves and involvement with the murders at the University of Idaho in November 2022. 2. The falsity of defendant's statements. 3. Defendant's awareness of the falsity of her statements. 4. The damages plaintiff incurred because of defendant's false statements. For defense, well, since this is plaintiff's proposed discovery plan, they don't know what she's going to want, so it's blank. She can fill it in. Discovery boundaries. Limits. The parties agree to limit the number of discovery tools as follows. Depositions, interrogatories, requests for production, all as said in the Federal Rules of Civil Procedure. So all of these, the Federal Rules of Civil Procedure set the number that you're allowed as a right. Now, unlike some of the Federal Rules of Civil Procedure, you can actually go to your opponents and say, hey, 10 depositions isn't going to be enough. I think I'm going to need 15. Are you willing to put that as the limit? And the defense will either say, you know, kick rocks, or they're going to say, you know what? I need at least 14. So yeah, why don't we say 15? And then by stipulation, it's 15. But Professor Scofield is suggesting for these as set in the Federal Rules of Civil Procedure. ESI checklist. The court has attached the checklist for ESI discovery prepared by the Federal District Court for the Northern District of California to assist counsel in their meet and confer session. Counsel should refer also to District of Idaho Local Rule 16.1b. Proportionality. Although not a hard and fast rule, a party from whom ESI has been requested in the typical case will not be expected to search for responsive ESI from more than 15 key custodians that was created more than 5 years before the filing of the lawsuit, from sources that are not reasonably accessible without undue burden or cost, or for more than 160 hours, inclusive of time spent identifying potentially responsive ESI, collecting that ESI, searching that ESI, and reviewing that ESI for responsiveness, confidentiality, and for privilege or work product protection. The producing party must be able to demonstrate that the search was effectively designed and efficiently conducted. So, what's this? Basically, Guillard's TikTok, by definition, involves electronically stored information. It's video online. So, Professor Scofield is going to ask for and ask her to preserve, but going to ask her to produce all videos made about Professor Scofield. And they're going to want it from Ashley Guillard. Now, Ashley Guillard might say, hey, look, I don't have this in my possession. This is stored on TikTok servers, and that's going to cost a lot of money for me to get them to provide them to you. And so it's not proportional to expect me to bear the cost of that. So either you pay half of it or get lost, go get it yourself. TikTok has it, not me. And in which case, Professor Scofield can subpoena from TikTok and say, hey, we want all the videos that have ever been on this account. So ESI file format. The parties agree to produce documents in the following file formats. Check any that apply. PDF, TIFF, native, and or paper, which is not selected. It's always good to submit in PDF because, you submit in Word and Word can easily be changed. PDF can also be changed, but it's got more safeguards. ESI production format. The parties agree that documents will be produced, check any that apply, with logical document breaks as searchable. It's a real dick move to send unsearchable, basically send PDFs, but instead of sending original PDFs, print them, scan them as images, and basically so you can't search them and you've got to manually do a document review instead of searching for keywords. Of course, if you do that, I'd just go to the court and say, hey, judge, they're playing games. Make them send me the original PDFs that are searchable, or have them pay for my document review. So they also would have with load fields enabling review in common litigation databases such as summation and concordance, with metadata, and if so, in the following fields: author, recipients, file name, regarding/subject line, date created and date edited/modified. ESI search methodology. The parties have agreed to use the following search methodology. They did not click predictive coding or technology assisted review. They did click keyword search. Deadlines. The deadline for the completion of fact discovery is December 15th, 2023. And that was in the proposed scheduling plan. The deadline for completion of expert witness discovery is January 5th, 2024. Documents protected from discovery. Well, for starters, that would be all attorney work product, attorney-client privileged matters and stuff. Clawback. Pursuant to Federal Rule of Evidence 502D, the parties must request the court to enter an order that production of a privileged or work product protected document, which, whether inadvertent or otherwise, is not a waiver of privilege or work product protection in this case or in any other federal or state proceeding. The court will enter such an order in its CMO unless the parties object or otherwise request that no such order be issued during the telephone scheduling conference. So it happens. Sometimes attorneys send documents that are clearly protected by the attorney-client privilege. And what you're supposed to do as the opposing attorney, if it was clearly done in error, is you stop reading it the second you realize that it's privileged. And then you're both going to call them and email them to create a record. So what you're going to do is you're going to email them and say, you accidentally sent this. I stopped reading the second I realized and only read this far until I realized, and I am deleting it. And then you call them because they might not immediately see their email, and you say, hey, moron, you sent this. Except you don't say, hey, moron, but it's what you're thinking. And you sent me this. I stopped reading it. I deleted it. What else is there to say? What do we... And that's the end of it. Some people unethically read the whole thing, and then they do the other steps and say, oh yeah, I deleted it after I read the whole thing and I'm using it. That's unethical. So, quick peek. The parties agree that a quick peek process pursuant to Federal Rule of Civil Procedure 26B5 is not necessary in this case. Post-complaint communications. Communications involving trial counsel that post-date the filing of the complaint need not be placed on a privilege log. Communications may be identified on a privilege log by category rather than individually if appropriate. Protective order. The parties do not anticipate needing a protective order, but they have agreed to submit a protective order for the court's approval to protect personally identifiable information if necessary. And B, the parties understand that, even if they agree to seal material filed with the court, they must still file a motion to seal and obtain court approval that the sealing meets the Ninth Circuit standards for sealing C. Kamakana versus City and County of Honolulu from the Ninth Circuit in 2009. So basically, the protective order would seal the discovery evidence, basically keep it from being disclosed to non-parties. And that's the end of the discovery plan. So, like I said, it's fairly straightforward. Both of these are pretty bog standard, even though Ashley Guillard has not agreed to this. It really is. You could see it went down the checklist. It it was, they clicked some boxes, didn't click a few others, but Guillard is demanding simply outrageous things, but she's not going to get them, with the exception of, scroll down and find it, with the exception of filling in these for the defense. This is what's going to be approved, and the scheduling order has been stipulated, so it's obviously going to be approved unless the court has conflict somehow, but they're not going to. So that's where we are in Idaho. So next, let's jump to Las Vegas. And as I mentioned, so I've had comments on my previous two videos from Mr. Jensen, the attempted intervener, and those will be in my next video in addition to his 44-page document. But one of the comments was, because these are still slightly out of order, but when I discussed his motion for leave to file suggestions in opposition to defendant's motion to dismiss, and how I was absolutely confused by that. And in the comments, he was angry. He's, well, I filed a 44-page motion with that, and they only put that 2 pages up, and he's mad. He thinks the court clerk is obstructing him, and it's like, no, the judge ordered her not to file it. So we'll look at all of that later. But for now, we have the order denying 23 non-party Jason Jensen's motion for leave to file in opposition to defendant's motion to dismiss. It is further ordered that Jason Jensen must cease filing documents in this case. Jensen may only file a properly supported motion to allow his joinder or intervention, and he may file no other documents in this case unless the motion is granted. It is further ordered that the clerk of court need not file the documents that Jensen has submitted to date, and need not file any other document Jensen submits in this case, except a motion to join or intervene. Signed by Judge Andrew P. Gordon on the 15th of June. And that's by the federal district court judge, not the magistrate judge. And then clicking over, we have his official 2-page order denying. So it reads, non-party Jason Jensen has filed documents in this case, including a motion for leave to file in opposition to defendant's motion to dismiss. Jensen has also submitted other documents to the clerk of court in this matter. As Magistrate Judge Utah previously explained to Jensen, he is not a party or intervener in this case. Jensen does not demonstrate a legal basis for him to bring issues related to this dispute to the court's attention. Unauthorized filings waste resources, delay the court's ability to address meritorious matters, and abuse the court system. Jensen is not a party, and therefore, Jensen is not a party, and there is no identified basis for his joinder or intervention. Federal Rules of Civil Procedure 20, which is permissive joinder, and 24, which is intervention. I therefore order that Jason Jensen's motion for leave to file an opposition to the defendant's motion to dismiss is denied. I further order that Jason Jensen must cease filing documents in this case. Jensen may only file a properly supported motion to allow his joinder or intervention, and he may file no other documents in this case unless that motion is granted. I further order that the clerk of court need not file the documents that Jensen has submitted to date and need not file any other document Jensen submits in this case except a motion to join or intervene. Dated this 15th day of June, 2023 by Andrew P. Gordon, United States District Judge. And I think as far as Jensen goes, regarding official filings, that's that. Although, who knows, he might actually attempt to file a new, improved motion to intervene, but that's going to be smacked down too, because he can't show that he has an interest in the outcome of this case. Period. So, next, let's jump to Massachusetts and Castro versus Abrams. So, scrolling down, long, you'll recall last time we were here, we had the reply from Google. Remember, basically, we had Google filed its motion to transfer, or in the alternative, to dismiss the case. And Delete Lawz had his opposition. Google filed a motion for leave to reply. Delete Lawz opposed their motion to reply. It was granted. So Google replied. That's where we ended it last time. And I said, expect in the next couple days for Delete Lawz to file asking permission to file a Surreply. That's a reply to a reply. It's not that I'm psychic. I mean, I'm no Ashley Guillard, but he hinted in his opposition to the leave to file a reply that, well, if you allow Google to reply, I'm going to need a Surreply because they're going to bring new arguments and I'm going to have to reply. So, spoiler alert, Judge Burroughs allowed it. I mean, I'm coming after the fact, and she allowed it, and we got the Surreply. I would have leaned towards her not allowing it, but I would have said I'm leaning towards not allowing it, but it wouldn't surprise me if she did. Just that way, I don't think there's anything he can say that'll change her mind at this point. But this way, she's dealt with him. She knows what he's like, and he displays the narcissistic traits that he is always in charge and he must have the last word on everything, including this. So even though generally speaking, the moving party gets the last word, or at least has the opportunity for the last word, he's getting the last word. So even though we already know the outcome, let's look at his motion for leave for Surreply in opposition to YouTube, Google's motion to transfer or dismiss. Introduction. Plaintiff Jose de Castro, and I've only glanced at this. Okay, I've only glanced at this and have. I don't think I've even glanced at the actual Surreply, but at least this first page is almost carbon copy Google's motion asking for a reply. And remember in the past, I can't remember what motion it was. It was last year, but it was either one of his nunc pro tunc motions or motions for sanctions or something, where he basically copied a motion that had been successful in a different case, and it was denied, and he said, see, she's biased against me. This exact motion was approved in a different case, but because it's me, she denied it. And it's like, but the facts are different. And so I think that's partly what he was doing here, essentially copying Google's motion, so that if he wasn't granted a Surreply, even though a Surreply, is much rarer than a reply. Therefore, it's much rarer that a judge approves of a Surreply than a reply. But if he wasn't allowed a Surreply, he would have gone ballistic and, see, it's bias. I used Google's motion against them and she denied it even though she approved theirs. That might be part of why she allowed it. So, introduction. Plaintiff Jose de Castro respectfully moves this court pursuant to District of Massachusetts Local Rule 7.1b3 for leave to file a Surreply in further opposition to YouTube Google LLC's motion to transfer or dismiss. In support of this motion, plaintiff submits a memorandum of law which is fully incorporated herein. If allowed, the reply would be no more than 5 pages and would be submitted by June 22nd, 2023, or within 7 days of the court's order, whichever is later. Most of the arguments in YouTube's reply require little response, as their defects are readily apparent. Now, that was taken directly from YouTube's motion. Now, when Google said it, it wasn't meant as an insult. It was to say, hey, we're narrowing the scope of what we're arguing in the reply, because that's what you do with a reply. He's using it to insult their lawyers, I think. As their defects are readily apparent. See reply, where YouTube puts evidence in the record showing that plaintiff has works registered after arguing that plaintiff doesn't. But at least 2 of defendant's arguments are worth addressing in short reply. And once again, he has not. A 12b6 is decided on the pleadings. It is the complaint enough for a cause of action to survive, basically. YouTube saying in its reply brief to the motion to dismiss, that being the first place that evidence of the registered work shows up would mean that, no, you have not pled it. 12b6 is appropriate. So, first argument, defendant YouTube tries to cure deficiencies in its motion. However, reply papers may only address issues raised in the moving papers. It is improper to introduce new facts or a different legal argument in the reply brief, citing Lujan versus National Wildlife Federation from the Supreme Court in 1990, and U.S. XREL Giles versus Sardi from the Central District of California in 2000, and Gutierrez versus Cobos, 10th Circuit 2016, where a party waives issues and arguments raised for the first time in a reply brief. The problem is, it works both ways. So if let's think of it this way. So Delete Lawz started this case with his complaint. And we'll just say complaint, not bother, with amended complaints and all that. We'll just say complaint. Google filed a motion to dismiss. So think about it this way. Move everything forward a step. So he filed his complaint. Google's motion to dismiss is essentially the opposition to his complaint. And then his opposition to their motion to dismiss could be fairly looked at as the reply to the opposition to his complaint. So he can't raise new things. He can't raise new issues in his opposition to the motion to dismiss that were not in his complaint. They are waived. It works the same way. But if he raises them, if the first time something is raised is in the opposition, the first opportunity Google has to respond is in the reply brief. That's why they had the reply brief. They would have responded in their motion to dismiss if it had been in the complaint. But since it's not in the complaint, and the first time he brings it up is in the opposition, the first time they have to argue against it is in the reply brief. How does he not get this? Well, continuing, since YouTube did not raise in its motion the argument that copyright registration was untimely, YouTube's argument for untimely copyright registration is itself untimely and should be disregarded. But once again, they didn't raise the argument in their opposition, in their motion to dismiss, that copyright registration was untimely, because he never alleged copyright registration until his opposition. Even if YouTube is allowed to inappropriately raise the alleged untimely copyright registration of plaintiff's video, the video was actually registered prior to the second supplemental complaint in where it is mentioned. But it's not mentioned anywhere. You have not mentioned registration in any of your complaints. Not in the amended complaint, not in any of the supplemental complaints. Litigation isn't a surprise. It's not, haha, gotcha. You have to make the allegations yourself. But he says the video was actually registered prior to the second supplemental complaint in where it is mentioned, so their argument is irrelevant. YouTube doesn't support the legal basis of their untimely copyright registration argument anyway. Good job, Captain Conclusory. And we get more of his argument. YouTube can't use unpublished or out of district case law. Only I get to do that. So Cortez Ramos versus Martin Morales from the District of Puerto Rico in 2020 is an unpublished case that YouTube cites, wherein it was decided that where a copyright holder had filed a registration late, that the district court should not have dismissed the action with prejudice. Instead, it was decided that the action should have been dismissed without prejudice. Additionally, the copyright holder in Cortez Ramos could not cure the defect by amending the complaint. Here, plaintiff can cure any defect in failing to allege copyright registration by simply alleging registration in his second supplemental complaint. Additionally, Cortez Ramos ultimately relies on a district court case in the Second Circuit where the court admits to parting ways with several courts that have held that a post-registration amendment can cure defect in a complaint filed before a copyright claim was registered within the meaning of Section 411A. See Malibu Media LLC versus Doe from the SDNY in 2019. Finally, YouTube's argument is moot. In general, courts have agreed that they lack the jurisdiction to make a ruling on a moot issue, but have done so only in the matter of public interest. See Muskrat versus U.S. from the Supreme Court in 1911 and Flass versus Cohen from the Supreme Court in 1968. Oh, well, he tells us it's moot. Once again, Captain Conclusory, ladies and gentlemen. How was it moot? I mean, yes, courts do agree that they have no jurisdiction to make a ruling on a moot issue. That's not in dispute. But this is his entire argument for mootness. A conclusory statement saying, finally, YouTube's argument is moot. That's why I call him Captain Conclusory right there. I mean, you've got to tell us, how is their argument moot? What is mootness? What makes an argument moot? What is the case law on what mootness is? And why is this specifically a moot argument? This is not an argument. Then his second argument. Plaintiff never published the key video in its complaint. YouTube says that this fact contradicts plaintiff's first amended complaint, but the key video in this complaint was not mentioned until plaintiff's request to make a second supplemental complaint, and is also mentioned in the second supplemental complaint itself. The video is obviously not mentioned at all in the plaintiff's first amended complaint. Except we don't know which video it is from any of the complaints. I mean, you keep saying the key video. You have never said what the key video is. Google has surmised that it's the Hammer Boy video because it's the one that's registered, but you have not made any allegation. And furthermore, every single video mentioned in any complaint is on YouTube. The entirety of the second supplemental complaint is YouTube URLs that would indicate the only thing you've put Google on notice of is that you're suing over YouTube URLs. He still doesn't get it. But the video is obviously not mentioned at all in the plaintiff's first amended complaint, but it's obviously not mentioned at all in the second supplemental complaint either, unless it's a YouTube video. Even if it was published on YouTube even, which plaintiff denies, YouTube does not dispute that their terms of service only applies to products and services that YouTube provides to a user of YouTube's services. YouTube would have this court believe that allowing third-party users of YouTube to copy plaintiff's creative works is a product and service that YouTube provides to plaintiff, which is unconscionable. Allowing YouTube's users to copy plaintiff's works is not a service provided to plaintiff. And yet, he has no problem with fair use when he is the one using other people's videos in his live streams. If it was unconscionable, why did he ever agree to YouTube's terms of service in the first place? YouTube continues to be oblivious to the fact that they were joined in this action because of their third-party liability to the infringing users of their service. YouTube is trying to abandon this action. Abandon? They're trying to get it dismissed so that those users must take on YouTube's portion of the damages. It is possible that the YouTube user defendants in this action may need to make their third-party claims against YouTube under a forum selection clause between YouTube and those defendants. However, YouTube has not made the argument or provided evidence that those defendants agreed to the TOS. Instead, they purposefully mischaracterize plaintiff's complaint. Conclusion. Again, YouTube should at least be required to read the complaints in their entirety and plead relevant arguments. But so far, its motion to dismiss lacks any merit. Plaintiff should be allowed to amend its complaint, but plaintiff cannot amend its complaint. Only the claims in plaintiff's first amended complaint under 17 U.S.C. section 106(1) will be lost, but the first and second supplemental claims would survive, as well as claims under 17 U.S.C. section 501, which don't require registration according to statute. Ugh. Once again, I have read the complaint, all of the complaints in their entirety, multiple times. I have made the same reading as Google's attorneys because his alleged injuries are not alleged anywhere in the complaint. He has not alleged registration anywhere in any complaint. He has not alleged a non-YouTube video of his anywhere in any complaint, but he still doesn't get it. Oof. But since the court, for some reason, allowed him his surreply, let's take a look at it. Plaintiff introduction. Plaintiff Jose de Castro offers the following surreply in opposition to defendant YouTube motion to transfer case to Northern District of California, motion to dismiss for failure to state a claim. In support of this surreply, plaintiff submits a memorandum of law which is fully incorporated herein. In general, defendant YouTube's 49-page motion to transfer case to Northern District of California, motion to dismiss for failure to state a claim, was filed with many defects and failed to raise arguments. 49 pages, he says. 49 pages. Motion to dismiss. 49 pages, he says. 49 pages. Fun fact, the tables of cases and tables of authorities aren't going to count toward pages. So even though the PDF says 25 pages, the motion doesn't start until page 7 of the PDF, which is listed as page 1 of the motion. Scroll, scroll, scroll. The conclusion ends in the middle of page 16. So it's 15 and a half pages of motion. And then there's the exhibits, which are the terms of service. Exhibit A is the YouTube terms of service. Exhibit B is the YouTube Partner Program terms of service. So he says 49-page motion to transfer or dismiss. It's a 15 and a half page motion. Yes, this is nitpicking, but he's being intentionally obtuse or dishonest. But he's trying to make it sound like YouTube had 50 pages to make that motion, and they failed to, or 50 pages to make that argument, and they failed to make that argument in 50 pages. But it was 15 and a half pages that they made their argument in. In that motion, YouTube asked the court to do its work for it by vaguely asserting that plaintiff's complaint had glaring pleading failures, but that the court need not even look at those because they were only going to raise two issues. One, plaintiff filed in the wrong court, and two, plaintiff didn't have any works in the complaint registered. Memorandum of points and authorities. Defendant's wrong court argument. Even if plaintiff's registered work was published on YouTube, which plaintiff denies, YouTube does not dispute that their terms of service only applies to products and services that YouTube provides to a user of YouTube's service. YouTube would have this court believe that allowing third-party users of YouTube to copy plaintiff's creative works is a product and service that YouTube provides to plaintiff, which is unconscionable. Allowing YouTube's users to copy plaintiff's works is not a service that YouTube provided to plaintiff. If the terms of service doesn't apply, then the forum selection clause in the terms of service does not apply. Additionally, plaintiffs raised arguments with citations to authority in his opposition at ECF number 123, plaintiff YouTube. Plaintiff YouTube? YouTube isn't a plaintiff here, but YouTube is not a necessary party in this action. B, circumstances would have changed since entering into the terms of service. Changed circumstances, you say? What changed circumstances? C, YouTube must show good cause for the transfer due to the overweening bargaining power in any terms of service. He's making up the standard here. He's making this up. D, plaintiff should be allowed to amend its supplemental complaint to allege copyright registration. E, the terms of service does not license a a user's videos to YouTube for copying by other users. YouTube continues to be oblivious to the fact that they were joined in this action because of their third-party liability to the infringing users of their service. No, they get it. They're just saying you're wrong. They get that that's what you're saying. They're not agreeing with you doesn't mean they don't get what you're saying. They're saying you are wrong. YouTube is trying to abandon this action so that those users must take on YouTube's portion of the damages. It is possible that the YouTube user defendants in this action may need to make their third-party claims against YouTube under a forum selection clause between YouTube and those defendants. However, YouTube has not made that argument or provided evidence that those defendants agreed to the terms of service. Instead, they purposefully mischaracterized defendant or plaintiff's complaint. Here's the thing. YouTube doesn't have to allege that Josh and Kate agreed to the terms of service. It's irrelevant. Delete Lawz claims against YouTube involve him agreeing to the terms of service. That's what's important. No allegation has to be made about Kate and Josh and the terms of service. And it continues to be, number one, a red herring, and number two, extremely disingenuous for Delete Lawz to try to make it seem like he's altruistically including Google as a defendant. It's for Kate and Josh's benefit that I included Google as a defendant. Because if I didn't do it for them, they'd have to go after Google for Google's share of the damages that I'm inevitably going to get against Kate and Josh. If Kate and Josh think that Google's responsible, Kate and Josh can bring that up. It's ridiculous. Defendants no registered works alleged argument. No, it's not an alleged argument. It is an argument. I mean, it could be defendants alleged no registered works argument, but it's not an alleged argument. It is an argument. It's like, how many times have we seen sovereign citizens? If I remember right, Darrell Brooks did this a lot, and I took issue with it a lot. Darrell Brooks said, the alleged defendant. No, Darrell Brooks was the defendant. He was alleged to have committed crimes, but he was the defendant. There's no such thing as an alleged defendant. YouTube could have checked to see if plaintiff had any works registered before alleging that he had none, but they didn't. But that's not YouTube's job. It's your job to allege them. It is your job to allege them in the complaint. That their argument is not, and even now, their argument is not that you do not have registered works. It is that you did not allege any registered works anywhere in any of the complaints. It's a huge difference. Excuse me. Since then, defendants themselves have admitted evidence showing that plaintiff has works that are registered and named in the supplemental complaint. Plaintiff should be allowed to amend his supplemental complaint to add this allegation. Except, is it named in the supplemental complaint? I haven't seen it. I mean, admittedly, I haven't clicked on all the URLs in the complaint because, who wants to give him views? And but if it's in this, if it is named in the supplemental complaint, that means it's one of the URLs, and that means he put it on YouTube. And his argument that it's never been on YouTube until Kate put it on YouTube fails. Either it's completely unalleged, or it's admitting that he himself put it on YouTube, therefore the terms of service apply. Either or. I mean, of course, I've seen Kate's video. It's obviously fair use. And I mean, you know, I get the occasional comment, you know, Delete Lawz is a great person. How dare you not like him? How dare you speak ill against him? He's trying to protect us from those dirty pigs. And it's, if he had a winning argument, I'd say, you know, I I dislike Josh almost as much as I dislike Delete Lawz. I mean, I find Josh absolutely terrible. But in spite of my dislike of Josh, he still has the winning argument here. And here's the thing. Here's the thing. Delete Lawz himself is saying, well, this is the relevant video. As far as I know, Josh has never done anything with that one video. So his arguments against Google basically are an argument to dismiss Josh. So if I'm Josh, which thank goodness I'm not, let's jump back to the docket again and scroll. Okay. November 7th, we have number 53 on the docket, answer to complaint and counterclaim from Josh, and then 54 is the same from Kate. And Delete Lawz was, I believe, actually late, but scroll down on December 8th, we have the motion to dismiss Joshua Abrams' counterclaim. Let's see. Yeah, so on the 8th, we have the motion to dismiss Josh's counterclaim. And then on the 11th, we have the motion to dismiss Kate's counterclaim. And then we have, let's see, Kate and Josh filed their motions to dismiss the first amended complaint and first supplemental complaint on December 23rd. So those are all still pending. Now if hang on, let's go back up. So 23rd, motion to dismiss. On the 27th, we have the opposition to Kate's motion to dismiss. Wait. Okay, sorry. It's the opposition to Kate's motion to it's Kate's opposition to Delete Lawz motion to dismiss her counterclaims. Sorry. So let's see. So I don't see I could be wrong. Okay, no, on the 6th. So memorandum in opposition to 95 motion to dismiss for failure to state a claim. So basically, if I'm Josh, I might actually ask for a reply to that. I know it's technically past time, but Judge Burroughs basically put a pause on that until the second supplemental complaint and said, if I need a new motion to dismiss from you, I'll let you know. Well, if I'm Josh, I might actually right about now ask to do a reply myself to that and say, hey, in these last couple filings concerning Google, he's saying the key piece of the key video is something that has absolutely nothing to do with me. So, but by Delete Law's own admission, I should be dismissed. You get what I'm saying there? Either way. So, his third argument, defendants can't lawfully raise new arguments in their reply. Now YouTube wants to attempt to cure the deficiencies in its motion by adding additional arguments that it didn't initially raise. Reply papers may only address issues raised in the moving papers. It is improper to introduce new facts or a different legal argument in the reply brief, citing Lujan and Giles versus Sardi and Gutierrez versus Cabos, same as in his motion for the Surreply. And Cabos still says a party waives issues and arguments raised for the first time in a reply brief. But once again, I'm going to be short since I've already said it multiple times. If you raise new arguments in your opposition, the reply is the only place for arguments against that. It's not that they're raising new arguments, it's that they're responding to your new arguments. They do not have Ashley Guillard's crystal ball. They couldn't have known what your argument would be until you made it. That's what the reply brief is for. Defendants' unlawful reply arguments about late registration. Where YouTube's argument is allowed, it is easily defeated. A, the video that YouTube alleges was registered untimely was registered prior to the supplemental complaint that added the video to the complaint. YouTube continues to beat their dead horse with amended complaint citations, totally ignoring the fact that plaintiff used a supplemental complaint, which is not an amended complaint. That's because the court gave permission for an amended complaint. The court has said amended complaint multiple times. Either way, who cares? Supplemental complaints never relate back, and they set out any transaction, occurrence, or event that happened after the date of the pleading to be supplemented. Federal Rule of Civil Procedure, Section 15D. The date of the supplemental complaint is after the date of the copyright registration, and the supplemental complaint was stipulated to by the other parties. But by this argument, though, the supplemental complaint is the only thing pending against Google, and really the only thing that can be pending against Josh and Kate, because nothing was registered before the first amended complaint or the second or the first supplemental complaint. Therefore, the second supplemental complaint is the only thing pending, and it is absolute garbage. I mean, you know, looking back at Ashley Guillard, she made a TikTok video saying, I'm going to use this complaint. I'm going to use this cease and desist as toilet paper. I wouldn't even use the second supplemental complaint as toilet paper. It's not good enough. YouTube alleges that plaintiff can't correct his supplemental pleading to allege registration based on an inappropriate case, Cortez Ramos versus Morales, which is an unpublished case wherein it was decided that where a copyright holder had filed a registration late, that the district court should not have dismissed the action with prejudice. Instead, it was decided that the action should have been dismissed without prejudice. Additionally, the copyright holder in Cortez Ramos could not cure the defect by amending the complaint. Here, plaintiff can cure any defect in failing to allege copyright registration by simply alleging registration in his second supplemental complaint. If YouTube thinks it'll be futile, then they won't be harmed by the amendment. Except, as Google has said, it's an administrative process, registration, that is an absolute prerequisite. So it must be dismissed. That the fact that it can be dismissed without prejudice doesn't mean it doesn't need to be dismissed at all. And once again, he has used so many unpublished cases himself. So many. So just by the unclean hands doctrine, he can't argue, I can use unpublished cases all I want, but Google can't. Additionally, Cortez Ramos ultimately relies on a district court case in the Second Circuit where the court admits to parting ways with several courts that have held that a post-registration amendment can cure the defect in a complaint filed before a copyright claim was registered within the meaning of Section 411A. See Malibu Media LLC versus Doe, which is a SDNY case. So just like Cortez Ramos is not controlling, it's not binding case law in Massachusetts, it's persuasive. Malibu Media from the SDNY is persuasive in Massachusetts. It's not binding. I mean, he wants to argue, look, they can't use this case, but I can use this one even though it holds as much water in Massachusetts anyways. Finally, YouTube's argument is moot. In general, courts have agreed that they lack the jurisdiction to make a ruling on a moot issue, but have done so only in the matter of public interest, which YouTube has not alleged and would be unable to prove. See Muskrat v. United States and Flash versus Cohen. Once again, Captain Conclusory, everybody. His whole argument. YouTube's argument is moot. And then finally, YouTube claims that plaintiff admitted in his first amended complaint to having uploaded the registered video to YouTube. This is false and is not alleged in the first amended complaint. Except you have... It is! Because every video... well, okay, maybe it's not in the first amended complaint. Maybe it's in the second supplemental complaint. But even there, YouTube's argument stands because everything you have alleged is to a YouTube URL. If the court grants the motion to dismiss, it should allow leave to amend, as it would not be futile, undue delay, or dilatory. Now, YouTube didn't argue about leave to amend, futility, undue delay, dilatory. They didn't argue that in the reply. But he's arguing it here in the surreply. But his argument up above was, if you don't argue it in your motion to dismiss, you can't argue it in the reply. You've waived it. But if once again, the reply is limited to arguing against basically new things brought up in the opposition. So a surreply would be only arguing against new things brought up in the reply. But since they didn't argue about leave to amend in the reply, he can't argue this. Can he? The federal rules of civil procedure embody a liberal policy in favor of allowing amendments to pleadings. Specifically, Rule 15A provides that courts should freely give leave to amend when justice so requires. And it has given leave to amend multiple times, to the point that it said any further amendments are going to be held to great scrutiny because you've run out of bites at the apple. The apple's gone. The orchard is burned down. This is the last one. And you wasted it on absolute garbage. I mean, let's see, it was there. The court told you before you filed this that this was essentially the last one. And you filed this. You filed this knowing this was your last bite at the apple. It's unbelievable. As the Supreme Court has instructed, this mandate is to be heeded, citing Foman versus Davis at the Supreme Court in 1962. Indeed, courts enjoy discretion under Rule 15A, but amendments under the rule are liberally granted and some justification is required for a refusal, citing Desrosiers versus Hartford Life and something Insurance from the District of Rhode Island in 2005, which itself quotes Ondas versus Barrows from the First Circuit in 1975, which says, so some justification is required for refusal. Well, amending would be futile. You've been given multiple amendments. You were told you wouldn't get any more amendments, except for, exceptional circumstances. Outright refusal to grant the leave to amend without any justifying reason appearing for the denial is not an exercise of discretion. It is merely abuse of that discretion and inconsistent with the spirit of the federal rules, citing Foman. But the thing is, this isn't outright refusal to grant leave to amend. He's done it multiple times. I mean, you don't get to keep amending. Almost, we're a few months short of a year into this. If you can't decide what you're suing about within a year or get the pleadings right within a year, it's going to be dismissed. I mean, if the court says, oh yeah, sure, go ahead, amend, we're going to be 10 years down the road still figuring out what he's even suing over. It's got to move forward at some point. And that, the court saying as justification, at some point this lawsuit has to move forward, and that point is now. That's justification. Plaintiff has registered a work before adding that work to the supplemental complaint, as evidenced by the defendant. Except it's not alleged in any of your complaints. That's what matters in analyzing a 12b6 motion to dismiss. You have not alleged any cause of action sufficiently anywhere. Plaintiff simply forgot to allege it. That means it's not alleged. Seriously? Plaintiff simply forgot to allege? Well, I simply forgot to allege one of the elements required to survive a motion to dismiss. But you shouldn't hold that against me that I forgot to allege it. It would be dilatory to amend the complaint before the motions to dismiss are decided, but plaintiff is willing to move for leave to amend if that's what the other parties want. No, they want dismissal. Well, plaintiff believes the court should deny the motion to dismiss in its entirety. To the extent the court grants the motion in any respect, plaintiff should be given leave to amend. Conclusion. For the foregoing reasons, plaintiff respectfully requests that the court deny defendant's motion to dismiss or transfer in its entirety. That was absolute garbage. I mean, I don't have much more to say that I didn't already say. I'm glad I covered the relative sanity of the TikTok psychic case before this, and I'm glad I saved Jensen's attempted motions for a different video because I couldn't handle more insanity right now. Oh. So, with that said, that's where I'm going to leave you today, and yeah. So, if you're, like I said, I've been saying this every video, even though I included some discussion of it at the beginning of this video. If you haven't been following the Scofield versus Guillard case, you should be. It's way more interesting. I find it more entertaining. go back, watch it all. You'll get hooked. You'll want to, you'll be waiting with anticipation for future filings in that. It's yeah. So with that, do all the YouTubey things, like, share, subscribe, and I will see you very soon. Thanks for joining me. Bye-bye.